Mr. Chief Justice, could we ask you about your opinion of the governor's call to change the Supreme Court appointment process? He even seemed to also use some very poignant rhetoric about the courts. If I could get you to respond to A, his plan to change the appointment process, and B, the way that he put it forth there in the State of the State the other night.
Well, we put together the present system in the late 1950s. I was not old enough to vote at that time, but my understanding through my readings and in talking with people who were voting at that time is that there were some political shenanigans in Topeka in the late 1950s, and as a result of those shenanigans, a proposition was put to the people to change the way that Supreme Court justices were selected. You all know it's called the infamous triple play. I don't need to go into those details. It passed both houses of the legislature by 2/3 vote. As I recall, it was approved by the governor, then it went to the people for a statewide vote, and it passed. We've had that system for almost 60 years now. Personally, I think it's a great system. It's known around the country as a merit system, and I think it is certainly worth keeping. I don't see anything broken with it. I don't see any problems with it. As you may recall, I have written about our system to say that one of the nice things about it is that anybody in Kansas who is qualified, in other words, has a license to practice law in Kansas and is of a certain age and a certain level of experience, can submit his or her application to try to get on the Supreme Court. So you could have perhaps 5,000 applications or more for an opening. So it's democratic for all the people in Kansas who would be qualified to apply. It's also competitive because you're going to have more than just one person apply, and my credentials would be matched against all of my other fellow applicants. They are my competitors, and through competition you find out who the best person is. So I like it for those two additional reasons. The other systems that were mentioned by the governor, electing Supreme Court justices, they spent a lot of their time campaigning for that office, and there was a case that you all may be familiar with that arose out of West Virginia a few years ago in which a coal company gave a lawyer, I think it was about $3 million for his campaign to run for a position on the West Virginia Supreme Court. That decision eventually went to the U.S. Supreme Court. Did I say it was for a seat on the U.S. Supreme Court or West Virginia? I meant to say West Virginia. Okay. You can read that case called Caperton. And one of the concerns in that case was that person who received the $3 million did win the election. He then sat on the West Virginia court, and then he got to be one of the decision makers on the case that involved the man who gave him the $3 million. So that is just an example of some of the problems that I see with electing your justices. In terms of the federal model that the governor mentioned the other night, I think you just look at the problems that come out of Washington, D.C. and say, for starters, that's not necessarily a good method. It does not allow for a competitive process. It is not democratic for all the lawyers and judges in the state of Kansas who might want to apply. As you know, it can be a simple matter of the governor picking up a telephone, calling somebody and saying, would you like to be on the Kansas Supreme Court? And if that person says yes, then they take steps to get that accomplished. So I'm not a fan of either of those methods. I happen to think that our system is excellent.